issues we've had with the penalties and that have accumulated on some of the Dawn customers by them not paying. And because of the issue with sewer-only customers, we have no ability to disconnect their water service as we do with other customers. So this is really designed for our sewer-only customers and will apply to all of our customers that have sewer. Ann Neal's advised us we can't treat one customer as different than another, so we've looked at just doing all of our sewer customers. And again, it's really not going to affect our residential in our normal county system, because at the end of 60 days we cut their water off, they don't have sewer. Basically what this has done is allows us to be able to stop accumulating the penalties, allows the residents a 60-month period to be able to pay back the debt that they've incurred up to this point. And if they were to become delinquent somewhere along the way, they would pay a 10% penalty on what they have, and their penalties would start accumulating again. In the most extreme case, if you look on the following sheet, there's a spreadsheet of the Dawn customers in no specific order, just kind of showing you some of those delinquencies. And if you looked at the worst case scenario, the customer would owe $77 over that 60-month period, plus their $28.50 monthly fee for $105 per month to pay that off. In looking to reduce these fees and reduce the debt that's owed to the county, we have proposed this. Some of the other things that have been discussed, and we're definitely open for discussion on this, is the board had mentioned about possibly waiving the penalty altogether. That's something we could look at as well, and they would sign an agreement that they're going to pay back their debt. As long as they stuck to that payment schedule, then we would waive what they've accumulated at that point. That's something we can look at as well. But we definitely need a tool in our toolbox to be able to work with the customers in Dawn. We have had a lot of contact with them in the last 60 days about their bills and where they're at. And a lot of them want to do something, but they're saying, hey, I got, $300 bill and I owe $280 in penalties and $28 in a sewer bill, and I can't afford to pay that. How can I do this? How can you help me? And we definitely want to help them, and I think we can, but we definitely need to figure a way out to be able to do that. And I know there was a lot of discussion with the board on this, and we weren't sure which way the board really wanted to go, but we definitely want to be able to put a tool in our toolbox to help these customers.
Board questions?
Joey, I got a question for you.
Yes, sir.
I see this. It says, some of the things that you can do in the event the customer does not honor the payment agreement.
That's correct.
The county would, claim against state income tax, obtain a judgment, garnish of wages. That's something we're not doing right now.
What we have started doing is the Treasurer's Office has been working on getting a claim against their state income, and we've received some of those payments this year. We're working on trying to do the other tools. Really have just been adopted recently by the board within the last 60 days or so when we approved the Dawn 2 project. Some of the changes were also in that allowed us to move forward on some of these other things. There have just been some amendments in the state code that we're reviewing to make sure that we're still in compliance with what we've just proposed because of what they have. So we're trying to make sure that we've got all that in place that we can do these other things as well. And again, really what we want to do is be able to provide the sewer service to that customer, have them pay their bill, and not get into these things. And what we're trying to do is get to a point where we can help these customers pay their bill down, get back where it's in a reasonable amount, and then if you don't pay your bill, these are the things that we're going to start doing in a particular order if we do not get any action from you.
Can I ask you a question? Have you ever, I know this is basically deals with this kind of deals with the Dawn system. What about the people, and have you ever had problems outside of, like, say, for example, in Ladysmith Village or wherever you have, have we ever had issues outside or?
Typically on the monthly cutoff list, because we cut off 30 days delinquent, which means you're basically 60 days behind on your account. We typically run between 12 and 20 accounts that we typically have to cut off. We typically send out 20 to 25 letters every month. Most of them are familiar names to us that we send a disconnect notice to. and I would say most of them pay by the end of that window, and typically it's less than 5 that we have to cut off on a monthly basis, and then we'll cut them off. Typically they'll call us same day. We'll restore their services when they pay their fees.
Okay, thank you.
It's definitely a different animal because we have that ability to cut water off. And
right.
When you don't have water, it hurts.
Yeah,
we've got no real way without creating an environmental hazard of shutting off the sewer.
Okay, thank you.
Other questions? I guess I have a comment more so than a question, Mr. Chairman.
Underwood?
Just looking at some of the penalties versus the sewer charge, I mean, you've got, the first one is not calculated correctly because the penalty is 46, 49, 38, and the sewer charge is 13, so that's well over 6,000 total bill, I believe if my math is correct, for $5,900 total bill on a charge of $1,300. I just think that in itself just is, I realize it's their responsibility, but that in itself puts a person in a bad position.
And that is one customer that hadn't paid a bill in 3 years,
Right.
and is actually one of the customers that contacted us and said, hey, we want to do something, we haven't, how do I get out of this hole? And they actually paid a payment, as you can see on 6/8, saying, hey, I want to do something, where can I start? So they did make a payment. But again, when you look at that particular customer that has $3,000 in penalties, $3,000+ in penalties, that's a significant amount. I don't know which number's incorrect on here. I guess when the penalties. All right, Fran helped put the spreadsheet together. 33, she said, on the penalties. So I don't know if the number didn't get added when the system added it. But
Right, 33, but 3 times the amount
Right.
of service. That's just ridiculous. I don't care. It's just ridiculous.
Tell me, the penalty is $10
no, it's 10% of your current bill.
of your current, so it's exponential.
Absolutely. So the farther you get out, the harder it is. It gets really big, when you get, and again, this isn't designed as a revenue for us, and especially, we actually budget revenues in the county system for penalties. We don't do that in the Dawn system. It was never really intended to make that a money-making effort. It's supposed to make it an incentive for the customer to pay their bill. And now what it is, we're beating them over the head saying, all right, you've got to pay X amount of dollars trying to get you out of the hole that it's almost impossible for you to get out of.
I guess my question is, we've got some people on here that haven't paid a bill in, 2 years?
And some of them are the same ones that haven't paid their home payment as well.
But I mean, if they have, so this, I mean, I understand what you're talking about when you talk about the what we can go after, but if they're not paying their bill, I mean, a judgment against them for delinquent accounts, a garnishment of wages, liens on the property, I mean, so that just goes on and there's nothing we can do about it if it goes 5, 6, 7, 8, 9 years?
It makes it really hard for us to be able to be able to terminate service on the sewer side.
I mean, you're telling me there's people that haven't paid a bill in 5 years.
The other thing that can happen is we would have to disconnect service. The building official would have to condemn the house, and we would have to ask the people to leave the home.
I thought that's what somebody said, 5 years somebody hadn't paid one.
But you said, Mr. Shebel, when you were just talking, you said some of these people who hadn't paid in a year or two are the same people that haven't paid their house payment?
That's correct.
The one first couple haven't paid their loan payments or their utility bills from the very beginning.
And they're not necessarily, they're new houses or just rehabilitated houses?
No, all of these were new construction. These were part of the Quinn Rivers project where they paid, and Fran administers that part of it, but some of them they haven't paid.
They've never paid.
Haven't paid that portion. I mean, some of those homes are $25 a month for a house payment, and their sewer bill is more than their house payment at $27.50. $28.50 is what it just went to July 1. So some of them haven't paid their $52, $53 a month for their sewer and their house payment ever since they've moved into the home. So those are some of the difficulties that we've had. Ideally, I think for us as staff, if the board would allow these penalties that have currently been accrued to be waived on as long as a contract was signed, a pay-agree contract was assigned to pay off their current sewer charges, we would waive their current penalties and not charge any new penalties through until it's paid off. We could set a length of time, and that would take off that big chunk of money that's over everyone's head, bring them back where we can actually manage and work with these customers. And then if they do not pay and do not come up with a very fair, reasonable solution to help them, then we go after these amounts. We can either, if they don't pay it, it's something the board could choose either to apply all these fees back on if they didn't pay it, those penalties, and then you could go against the total amount. There's a bunch of different things that we can do, and I really am looking for guidance from the board of what you all would like us to do to be able to help these customers. But if they didn't pay, then we would go after and go through these. But a lot of them said, hey, we want to help, we want to do something. I just can't afford $100 a month plus my regular bill. I can't afford, $250 trying to pay this off in a year and trying to come up to pay that penalty when they couldn't pay their original sewer bill to begin with.
I guess my concern is even if we do that and they still don't pay their bill, I don't know that, if they're not even making a house payment, then what? You're limited to the items here. You can eventually foreclose on the home. The things that I know nobody ever wants to do, but at some point, if the board wants to collect some of these funds, hard decisions are going to have to be made at some point to try to do that. Again, these are the last-ditch effort of trying to give them every effort that we can to make sure we can try to catch them up. Some of these people get Social Security checks. Well, not Social Security, but income tax return that we can try getting that. We can get a judgment against them from a judge. If they are working or have anything, it's possible they could start making a payment towards that. Putting a lien against the property, if they sell it in 50 years, then we'll get something out of it then. But unfortunately, from that standpoint, it doesn't do a lot for us. There are homes down there that are changing names and moving around more than I had realized. There's quite a few homes down there that are changing names and selling, and some of them are going from one family member to another family member, and so we're seeing some of that go on down there.
I don't have a problem with the liens because it doesn't necessarily impact the people that live there. If they sell it to pass it on to a family member or something, then that family member has to be responsible for the debt. I guess my concern is the fact that, we heard from 13 different households tonight that the homes that were built that they're having to pay back now is certainly inferior. That there were problems with, I don't know what the problems are, and I don't know what caused the problems. They say the inspections were not made. I don't know.
I think it's speculation at this point.
Yeah. But I think that those people, and I'm not sure if I wasn't in their position, I wouldn't feel the same way. I'd have a hard time wanting to pay for something that is extremely difficult to live in, or I'm going to have to go and invest a lot of money to bring up to livable standards. That's the reason these homes were built. That's the reason we put this program in place, is because the living conditions were not what it should be.
The homes that were replaced did not have indoor plumbing at all.
Right.
So it's
Right.
that was part of this grant money when these homes were built through Quinn Rivers as part of the Dawn project, and we went through and we got 2 pots of money.
Right.
Quinn Rivers managing the housing, and these homes, as we went through the Dawn project and found out that they didn't have indoor plumbing, that there might have been a toilet or just a sink. The toilet went outside just to no plumbing in the house. It just went out to what we call a straight pipe, really. So it was really to help them out.
Yeah,
So those were people that were in very poor conditions when those houses were built.
But the fact is, they not. A lot of people don't have the wherewithal in order to do.
Right.
I have no problem in foregoing the penalties. I do think we need to try to work with them and get them to pay the charges that are past due over a period of time. And then if we put liens against the property, then at some point, if it ever changes hands, we will collect those funds.
The new
But it
law
depends, I
has
think-
changed. We've got specific things we have to do in a specific order now. It's before you can kind of pick and choose what you want to do. The new law that's just come out says you have to do this, 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 and this, and in that manner, and in order to do that. So it's
I'll leave that, this stuff to
Yes,
you, to
thank
staff.
you.
I'm just voicing my opinion as to what I feel needs to be done here as far as trying to
Understand.
correct this problem. My point again, I go back to what I said earlier, 50% or 10% or 20% of something is a lot better than 100% of nothing, and we're getting nothing now.
yes, sir.
And so that's my
In some cases.
Mr. Thomas.
Mr. Shebo, and I hope the rest of the board will agree. I would like to take off as one of your tools, garnishment of wages,
Okay.
because if I'm working and I can't pay my house note and I can't pay my sewer note, I'm probably using all my money for food. At least that's what I'm hoping and trying to believe. So I wouldn't want to see you take somebody's food, okay? So the lien I think we'll eventually get, if just take the garnishment away, if that's,
And I think the claim against the state income tax monies is legitimate.
That's fair.
Because they'll
That's
only
fair.
take a portion, they're only
That's
going to take
fair.
a portion of whatever it is.
no, they'll actually take the whole thing.
Well, no, we got to get in line, and whatever's left, we will get, but I mean, we probably only get a portion of that. There's going to be, if they owe state funds, they owe other
Yeah.
funds, they're
Yeah,
going
if
to
they
come
own
first.
if they own
We
personal
only wanna
property
get
tax,
what's
real
left.
estate tax, all those things, you get lumped on there, and you
Yeah,
kind of get what's
I mean,
ever
they're
left.
all good as far as I'm concerned. I just
Yeah,
thought the
what-
wages was the one to leave. Take off.
Well, how about obtainment of judgment against the delinquent amounts? I mean, what are we asking for? What would we get?
That actually means
I think we have to have a judgment. The judge has to issue a judgment against that person that they owe us a debt before we can do other things.
But it doesn't mean anything, it just affects their credit rating.
We'll give it.
We don't have to get money from the judgment.
Mr. Chairman?
Mr. Underwood, that's your area, and
Mr. Chairman, and this is a delicate situation. I've met with a lot of the folks. Certainly, some of the folks have very nominal means. So I would like to see, definitely would like to see them paying their bills. But with the, like I said, with the penalties, I just think it makes it awful difficult for them to even get above water, get their head above water. I've talked to people who
agree.
just have, so if we could go back and look at the penalty removal and work out a way for them to begin paying, I think that's what, and I agree with you, Joey, 100%. We want them to begin paying and be paying customers. Again,
it's-
my concern about some of the houses, and I've been in some of the houses over the last 2 weeks, and I applaud them. I wouldn't stay there. I just wouldn't stay. I'd rather sleep in my car. But this thing is poor workmanship. It's just black mold. It's just, it's not a quality living. In 2012, I just can't believe that we let this continue and not have anything done. I'm just, like I said, I told them I'm angry about it, and I'm going to do everything I can. If I got to spend every dollar I can to make it happen, it's going to happen, because nobody deserves to live like that. I'm just appalled by what we've done.
Mr. Blackbeard.
I was just wondering if we could, and I don't have a problem with waiving the penalties, but, and I don't even know if it's legal, so this is why I'm asking, could you tell the customer we're going to waive, I mean, Joey, can you say we're going to waive the penalties, but you have to make your payment every month or the penalties come back? Condition. Can you make that a condition that say, all right, here's the deal, you've got, $2,000 in penalties hanging over your head, we will forgive them as long as you are monthly making your payment, and if you don't, these come back, and then these are the tools, and I don't have a problem, Mr. Thomas, with the garnishment of wages, but these are the tools we have to go after you, and we will be going after the penalties as well.
So aren't we doing,
Some of those.
Ms. Cosby, we're doing similar to what other places do, like the IRS, and they said, we're going to settle for, you owe us $4,000, we're going to settle for $1,000, and that's it. If you don't pay the $1,000, can we come back and get the $4,000?
Yes, and I think that's what's in the language, or
In the agreement, he's got to
in the amended language. Should the account not be paid within the full 60-month grace period? Joey and I had talked about, whether the
5 years.
full amount of the penalty, would come back, or whether, and I think in this draft, a 10% penalty on the outstanding amount, would be imposed. But certainly, I mean, it's up to the board. Do you, whether, what amount of the penalty comes back? And that's absolutely within your discretion.
I think the only thing I would add is you would have to pay your current payment and a portion over whatever period of time for a maximum amount of time to recuperate the current sewer fees that they haven't paid. So we'd have to work those two numbers out to make sure that they're making a payment to do that.
I guess my only question now is it a full, if they start, going delinquent again, is the full penalty coming back, or is just 10%? I mean, I guess what's the deal there?
I think we can probably say the full penalty is coming back at this point, and then if the board can talk about it at that point if they do not. But I would think the full penalty needs to come back. We're making a good faith effort in trying to help them. Okay. And if I could, if I calculated correctly, the person that owns the $1,304.70, that's going to be about $22 a month, just to over 60 months to get that paid up. And so, you're talking about a $50, $51 sewer bill every month, including the current cost as well as the other. And I think that's fair. Mr. Underwood? Yeah, okay. And so that's what we'll...
Okay. I think we've got some good guidance on that. Mr. Chairman, I don't know if you would like to come back for a first reading with those amendments, or if you want to move forward.
You want to move forward to the public hearing, or have another second meeting, or just go ahead, move ahead? All right. Public hearings on all of these will be on the last meeting in July.
Yes, sir.
All right. Thank you, Mr. Chief.
Thank you.
Next item on the agenda is first reading of proposed ordinance of the Board of Supervisors electing to assume the power to consider petitions for the creation of a community development authority or authorities. Mr. Wilson.
Good evening, Mr. Chairman, members of the board. This is your first reading for the Community Development Authority ordinance. You have in your packet our memorandum regarding this ordinance. It's a development tool, and if that's the three things I would start off with to make sure that we clearly indicate this is a tool for economic development, and it is also a tool that will generate revenue. And the best part of this is it creates absolutely no debt obligation for the county whatsoever. We have, I'm pleased to say this evening, two experts on CDAs with us this evening, Mr. John Markowitz and Nate Bettenham from Stifel Nicholas, whose firm is the national leader in underwriting CDA and TIF bonds. And we have them here to make a presentation to you this evening to clearly indicate the advantages of this ordinance.
Good evening, Mr. Chairman and members of the board. My name is Nate Bettenham. I'm a managing director with Stifel Nicholas. What I want to talk about, I'm going to start off with what is a CDA, Community Development Authority. Okay, yeah. A CDA is a public body that's created by the County Board of Supervisors. It has board members that you would name. Its purpose is to promote economic development in a specific district that you would specify. Its primary power is to finance public improvements. If you want, it could also acquire, construct, equip, operate, maintain, and provide special services related to those public facilities. But typically, the primary power that a CDA authorizes is the issuance of tax-exempt bonds. These bonds are for public improvements, for public infrastructure improvements. Typically, they would be for public water, sewers, roads, perhaps a train station. They're for public facilities that would be owned by a governmental entity, perhaps the county, perhaps the state, perhaps the CDA, if you were so inclined. The bonds typically are at least $10 million, so these are for major projects, and where you, as the Board of Supervisors, want to promote economic development. The repayment of these bonds comes from one of three ways. It can come from, and you would be the one that would determine which approach is used. They could be special assessments, they could be TIF revenues, or a combination. The special assessments would be in an amount, presumably, that equals the debt service on the bonds, and they'd be allocated amongst the property owners in the district. The property owners would petition the CDA board saying that they want those assessments imposed upon them, and then as they sell the property, the assessments would carry over with the sale of the property. And these assessments are over and above regular property taxes and other taxes that might be imposed. TIF or tax increment financing is another way of repaying these bonds, and that is the increase in property taxes, of regular property taxes, and occasion other taxes that if a property is more valuable as a result of development in the district, if because you're building a sewer and a road or a train station, you've now attracted residential, commercial, office construction, and this private development pays more taxes. First, those taxes the increase in those taxes would go to pay the bonds. And then often we could have a combination where if the TIF revenues are insufficient, if there's not enough development that occurs, that the assessments will be used to make the payments on the bonds. This debt is not, the bonds are not a debt or an obligation of the CDA, and they're not a debt or obligation of the county. In fact, under state law, the county cannot, absolutely cannot, make any appropriation to pay this debt unless, when the bonds were initially authorized, they had agreed to do so. Typically, that's not the case, and typically the bonds are repaid strictly by the assessments or the incremental taxes. So the risk is then taken not by the county, but by the developers and by the bondholders. So in underwriting these bonds, we as an investment banking firm want to make sure that there's going to be plenty of private development that will be able to pay the assessments and pay the taxes to support the payment of the bonds.
Members of the board, Mr. Chairman, at a time when localities and states and the federal government are facing severe budget and revenue issues, the attractive thing about a CDA TIF, as Nate said, is that it's an economic development tool that advances and accelerates economic development projects that otherwise may not occur in this economic environment. And that is by having infrastructure financing, a plan for that in place. So it allows a locality to finance infrastructure that may not be able to be financed in today's economy, often much sooner and at a higher level. And by generating these economic development projects through a CDA TIF, it often leads to job creation, a preservation and strengthening of the tax base. There are studies that are done to say if you have an economic development project and it's done without a CDA TIF, this is the taxes that would go to the county. If you do have a CDA TIF, these are the taxes that would go to the county. There'd be a portion for debt service, but after that, all of them would go back to the county. And so it's taxes that you otherwise wouldn't have. That's the idea behind them. And as Nate said, it shifts a portion of the burden for the infrastructure to the developer. The developer's saying, we're going to put our property on the line as collateral for these bonds in exchange for the infrastructure and some cooperation with the share of taxes. These are done all over the country. In Virginia, they're called community development authorities. Different states are called different names. North Carolina Special Assessment District, Georgia Tax Allocation District. 49 states have tax increment financing statutes. Arizona is soon to be the 50th. These are the CDAs in Virginia that have issued bonds. There have been 21 of them. Most recent was one that our firm did last year in Fairfax County. But our firm has done the majority of the CDAs in Virginia. None of our deals have experienced any payment defaults. And we get calls every day from localities and developers who are looking at this infrastructure tool because localities don't have the money or the resources to pay for the infrastructure oftentimes. And developers can't justify in their economic model to make a development move forward in today's economy.
Okay. I mean, first of all, several of these projects are mixed use, several are residential, but and some have office, some have just retail. But one that I understand that you're interested in office, so we brought an example that was a pure office, and this was the National Business Park in Anne Arundel County, Maryland, outside of Fort Meade. Originally, this development was a $20 million bond to finance roads and sewers at adjacent to Fort Meade, and the original bond was done in 2000, and it was so successful there were several $100 million of development that resulted that the county came back and now financing, or in 2010 we did bonds to finance that extension off to the upper left where the red dots are, and that was another $30 million issue that again will presumably almost certainly will generate several $100 million of development. The county experienced tremendous growth in taxes over and above what was needed to pay debt service on the bonds. Here, the project has been occupied by government and primarily government contractors, defense contractors, but also the U.S. government.
And the only last two things we'll point out is that our firm is the national leader in both tax increment and land secured bonds. So we look at these deals every day, and we continue to see more and more interest. So we're available for questions if you have any.
I have a question, first of all, and then I'm going to have the rest of the board to ask questions. Number one, have you been involved in any of the CDAs that have just not made it and had to fold? And if so, what happened?
Let's see. Well, I think there have been some problems. I think particularly in Florida, our firm was not involved in any of the projects in Florida. There were a number of problems. In California, where we were pretty much the dominant firm, we have well, last we checked in January, there was, I think, just one of the probably 500 projects that we financed that was in a payment default. But I know there are a few projects that we are working with that have we're working with developers to try and get it going, but it hasn't gone back to the county or anything like that. The bondholders just take a hit.
I see. Now, so I think the project that we're looking at trying to, or that they are looking at trying to develop the CDAs on, is one in particular. So we can say the parameters of that particular project is a CDA in itself?
Yes, yeah, absolutely.
And so anyone outside of those boundaries would not be affected?
Correct.
Okay. Thank you. What, Mr. Thomas, you have a question?
Yes, sir. Gentlemen, thanks for coming. Were you two with Stone and Youngberg?
Yes, yes, our firm,
So you got acquired?
yeah, we were
Okay.
acquired about
And-
6 months ago.
And Stifel,
Stiefel Nicholas, yes.
sorry, that was a
Yeah,
Freudian.
yeah.
Stiefel is based in San Francisco.
No, Stiefel is based in St. Louis.
You were based as
Stone and Youngberg.
Stone and Youngberg, you were based in San Francisco.
Correct.
Okay. So the ones we showed, the ones Fairfax and all those were Stone and Youngberg's, or those were Stiefel?
Well, Fairfax Mosaic was Stiefel. The others were Stone and Youngberg.
The other was, okay, so they did one of those, and you guys did the rest,
Well, we were.
and then you were acquired.
We were we're now the Stone and Youngberg division of Stiefel. So,
Okay.
okay.
And in my personal
Okay.
life, I've been acquired, so I understand.
Okay. Okay.
Sometimes it's good, sometimes it's not.
Yeah, no,
And
this has worked out just fine.
I just wanted to make sure I knew who was who.
Yeah.
Okay. So you're basically selling municipal bonds,
Yes.
and if I wish I had a lot of money, I would buy a bond because I think there's going to be a fairly good return, right?
Right.
That's kind of the way the process works.
Right.
And as Mr. Akers asked, you've only had the one in California you were talking about that
Yeah.
was a problem, and in that case, the people who purchased the bonds just basically lost their money,
Well,
nothing
some
else.
of their money. Right.
Some of it. Okay. So, I mean, this is much like, it sounds much like what the Industrial Development Authority does in the county,
Sure.
but when the Industrial Development borrows money, because they built a few things for us, the county's kind of morally responsible for that obligation. And you said in this case, the county is in no way responsible for that obligation.
Correct. In fact, as I mentioned, under state law, the county is precluded from making any payments to shore up any defaulted bond.
So really the real catch in this whole process is how you can sell these municipal bonds to other people. And
Yes.
that's why you guys are wearing nice suits, because you're good salesmen, right?
Right, right.
Okay. All right. And you're sure there's not even a moral obligation?
Not even a moral obligation, no. I mean, it's very explicit that you cannot make an appropriation.
And all of the bonds that you sell have to be used only within the CDA area?
Only within the CDA area and only for public infrastructure.
The infrastructure can abut and be contiguous to the CDA. It's got to connect to it.
Yeah, so basically I've got water 500 feet from where this is going to be.
Yeah, or a
You
sewer
would-
line that's
Or
coming.
sewer line, you
Yeah.
would pay for that, and you'd
Yeah.
pay for whatever expansion.
Right,
And that would only be the responsibility of CDA.
correct.
Okay, thank you.
Mr. Taylor, you have a question?
I guess my question is, what happens to the areas when you're not successful? I understand that local government is not responsible, but when you go in and you make your investment and you get started with a project and it just doesn't work, what happens? Who cleans it up?
Well, there's a bond trustee involved that would work on behalf of the bondholders to try and get things cleaned up, and that's generally what happens.
But at the very worst, the bondholders, they have a lien on the non-governmental property within the district, so they would foreclose on the district, assuming that the bonds weren't structured right and the project didn't move forward. The bonds would be issued, the infrastructure would be put in the ground, and then the project would be foreclosed, and there'd be a new owner that comes in and takes the project, but it would be fully entitled and have all its public improvements in place.
Okay.
The county would have no debt for any of that.
Okay. I noticed that a lot of the areas that I saw up there are urban areas. I didn't see a lot of predominantly rural areas. So how are you going to be successful in a predominantly rural area where there is, no infrastructure or a lack of infrastructure? I know you provide those, but,
Yeah, well, we'd have to be in a situation where there was a commitment to build the vertical improvements so that there would be taxpayers there to make the payments, but they'd have to go hand in hand together.
So the people who buy the bonds basically.
People that buy the bonds are going to be looking to make sure that the developer has in place commitments to have vertical development take place.
And as I understand it, the board is accepting, tonight is talking about being able to accept CDA petitions. So once a petition for a specific project comes forward, then the board and bankers and financial advisors can evaluate that project if it does make sense in a rural area. But there were a few on there that were rural, but it all comes back to the real estate project.
Okay. All right.
Mr. Seeley?
In our packet, we had a memorandum, and under details, it says, no project can advance without the approval of the Board of Supervisors. If the conditions of the development financing deal are not satisfactory to the Board of Supervisors, the landowner/developer will either be denied or the conditions modified to meet the approval of the Board of Supervisors. Why would we care how you're financing if you guys were a CDA?
I think the answer is you want it to be done right, so that the county would enter into a development agreement with the developers and make sure that it's developed as the county wants, the right component mix, and the right timing. Most localities care about how the project's done. They're not liable for it, but they don't want to see a project go bad in their locality.
Yeah, it'll be your sewer line or your water
Well,
system.
let me talk about do you finance apartment complexes?
No, we don't finance the apartment, but we would, if, for instance, in that Fairfax Mosaic bond issue, there were part of the vertical was apartments. There was.
We do public infrastructure with taxes and bonds is our specialty.
Roads, water and sewer, those
Yes.
sidewalks,
Public
those types of
purpose or
things.
public ownership in general.
So no
Yeah, or a rail station. Yes.
A rail station, yeah, the rail.
bridges over the tracks to the train station?
Could be, yeah.
But no
We don't finance.
dwellings, no buildings?
No buildings. Unless they're a public building like a train station, publicly owned.
So you said train stations. Now, the project we're talking about, it's Carmel Church
Yeah,
Station.
Right.
Would we be able to have a CDA that covered Carmel Church Station and then maybe just ran parallel to the tracks and opened up again at Milford?
Sure. I mean, the one example I can think of a train station was not.
I'm just asking if there was, the point of that is there possibly with this CDA there could be a train station at Carmel Church Station and one at Milford. Commuter rail at Milford may be different. It could be the same thing?
Yeah. I mean, you may have two different CDAs for one.
Oh, different. Okay.
Yeah. Okay. Yeah. But I mean, the one example I can think of where a train station was financed was in Washington, D.C. There was a metro station that was financed, the Noma station. There was the red line that went past that community. They created a special taxing district, and they taxed all of the property owners in that area. And that was part of the local contribution to allowing payment for that metro station.
Well, I understand that some of the CDAs have had problems in these economic times in just collecting because the value of what they thought they had before the collapse and the value now is different, and actually getting people back into those buildings that have been built out of the infrastructure has been tough because of the additional tax rate.
And none of our CDAs have had payment defaults, but several have had stress, just like most real estate projects in this recession. But they've functioned how they're supposed to when there's TIF and special assessment. If the taxes aren't enough in a given year, then the developers, they have to pay that shortfall. And so that's how those work. There have had some that have had problems, and none of ours have. a lot of it goes back to your question about the private construction financing. That's such an important part of how we underwrite these bonds, because we have to make sure that the private project is going to move forward so we can repay the bonds, and generate the taxes to repay the bonds. So that's a very important part, and a lot of the CDAs that had issues, there was not a construction financing in place for a lot of the private projects.